Morning, Chris. How are you?
Good morning, Michael. How are you?
I'm doing well, thanks for asking. So today we're going to continue on our discussion from last week. Just a reminder, we talked about the criminal appeals and kind of what that process looks like. Just kind of on a general sense and how quickly you should do it if, in the event that you are convicted of a crime or if you're plead guilty, things like that. But one of the things that we didn't talk about was what actually can you appeal and what do you actually argue on appeal should you decide to go that route.
Yes, Michael. Uh, it's an important subject because uh, if you don't succeed in the first round, if you will, whatever court you're in a criminal case initially, if you don't succeed there, very often you can appeal what you have been unsuccessful with in the first round, in the first court that you've appeared in. But you have to protect yourself. And by that, lawyers refer to it as protecting the record. Making a record is what lawyers also refer to. Uh, and what they mean is in case you have to appeal. If somebody were to call, like somebody called up with this topic, this appeal topic, um, it's because they've been unsuccessful. And what do they do now? Typically, if they've had a lawyer, the lawyer will know what to do to protect that record, the record in the trial court, the court that you first go to, how to make a record, what issues you should raise in that court in the first instance. But if you're now on appeal, you're very often limited on the appeal to whatever it was that you raised in the court that you were first in. So if you have a court or a case rather, where the first court that you're in is, let's say, a town court, and you have gone to trial and been unsuccessful there, you have to have already made sure that in that court you have a court reporter or some type of a recording device that will make a record that you can then use. If you have a court reporter, you have to order the transcript, and that involves taking some quick steps after the trial's over and ordering that transcript. You have to file a notice of appeal, which is the first step in an appeal. And I referred to it last week. And you have to do that in a short period of time, typically 30 days after you've had the unsuccessful result in the first court you're in.
Right.
And I'm sorry, you were going to say?
I was just going to say, so we talked about kind of the technicalities, but one of the questions that we got last week and what people are curious about is what actually can you appeal? Is it just I didn't win, I want somebody else to say why? Like, what is it that you're going to argue on appeal?
Well, you have to argue that there was some ruling that did not go in your favor. It's not just I lost, here's my appeal. It's I lost because the judge in the court below or the jury in the court below made some decision or ruling that was unfavorable to me and prejudiced me. And for some technical reason, very often it's a technical reason that that caused the jury or the judge, if the judge is deciding the ultimate fate, to rule against me. So
when you say,
I'm sorry?
Could you give us an example of like a technical issue that might pop up that you've seen?
Well, like a ruling on whether typically if it's a jury, you have to be very careful about what this jury learns about the defendant and about very often a defendant's prior criminal history. And if a ruling has been made that the jury, if we have a jury, that the jury has heard that the defendant has a prior criminal record, and the defendant's prior criminal record is now displayed to the jury, so to speak. The jury knows that the defendant's been in court before, and the defendant has had prior cases for which he or she has been found guilty. That is an inherently prejudicial ruling, and very often becomes grounds for an appeal. That's the type of issue that you can raise on an appeal if you have objected to it in the trial court and the judge has overruled your objection and decided that the jury can hear that.
So that's what you meant by making that record?
Yes. Very
sense.
often, unfortunately, we see defendants who appear in local courts, and especially on less serious matters like traffic tickets, and they have been representing themselves, which I cannot recommend, because very often we'll say to someone, well, why didn't you at least call us and we would have discussed it with you beforehand? And the person says classically, well, I didn't think I need a lawyer. But if you have rights that are at stake, such as your right to operate a motor vehicle, that's a very substantial right in New York, because most people don't live in New York City. Most people live outside of the city, and they desperately need a driver's license for things like work. And they're therefore unable to work, or the very lack of a driver's license not only threatens their employment, it does away with their employment, because very often they'll have a job that driving is something they do in the course of their employment. So if they lose their license for something like a DWI, and the first instance that they go to a lawyer is after they've been convicted in the local court, that's too late. I say it all the time, and I've said it repeatedly on this show, that it doesn't cost somebody anything to call a lawyer who's competent in that area of law and to discuss with that lawyer on the phone things like, do you think I need a lawyer? People sometimes think that the lawyer will, of course, say that you need a lawyer because it's good for the lawyer's business, but that's not the reason the lawyer in most instances is giving the response that you need a lawyer. I always say that we're not the only lawyers around, but that somebody should make it their business before they go to court to speak to a lawyer, even if it's by phone, about, do I need a lawyer? Because if you have a lawyer who's skilled in that area of the law, that lawyer knows things like making a record and protecting the record are what that lawyer lives and dies by. And so you at least have a transcript from the court below. And so if you appeal to an appellate court, whether it's a county court from a town or a village court, or an appellate term, which is one of our appeals level courts, or an appellate division, if it's from a more serious matter in the county court, you have a record that you can refer to, because it's very painful to see an appellate decision on an appeal where the court says that the record was not properly made in the court below, and so we cannot do anything about that because it's being raised for the first time on an appeal. Certain things you can raise for the first time on an appeal, but many more things you cannot. And so you've now waived them.
All right. Well, thank you, Chris. That was very informative. We're going to finish up this conversation next week with a very kind of specific avenue, which is called ineffective assistance of counsel in the ways that interacts with potential immigration issues. So we appreciate the time, Chris. We'll see you next week.
Thank you, Michael.
Take care.